Good morning, guys. Welcome to Mug Briefing. A federal judge in New York just made a decision that keeps alive a lawsuit over how one of America's biggest banks handled customers' idle cash. The ruling does not say JPMorgan did anything illegal. It says the customers are allowed to keep arguing their case in court. In simple words, the judge decided the complaint is strong enough to continue, and that matters because it puts a spotlight on how banks pay interest on money that many Americans leave sitting in brokerage and retirement accounts. Here's what happened step by step. On February 13, 2026, U.S. District Judge Lorna G. Schofield in Manhattan issued an opinion in a proposed class action against JPMorgan Chase. The plaintiffs represent customers dating back to August 24, 2018. They claim the bank paid extremely low interest, around 0.01% to 0.03% on certain cash sweep accounts at a time when short-term market rates were above 5%. A cash sweep account is basically a parking lot for money. When customers hold cash inside a brokerage or retirement account and are not actively investing it, the system automatically sweeps that money into a deposit program where it earns interest. Most customers do not manually pick a rate each day. The sweep is built into how the account operates. The plaintiffs argue JPMorgan's contracts required the bank to adjust interest rates based on business and economic conditions and to pay a reasonable rate in certain retirement accounts. JPMorgan asked the judge to dismiss the case before it went any further. The bank argued that the claims did not hold up legally. Judge Schofield rejected that request in part. She allowed key breach of contract claims to proceed. At the same time, she dismissed other accusations, including claims that JPMorgan violated fiduciary duties or made improper investment recommendations. That narrowing is important. The case is now focused on contract language and disclosures, not on broader claims that the bank acted as a financial advisor with special legal duties. No money changed hands because of this ruling. The judge did not award damages. She did not rule that the rates were unfair. She ruled that the customer's contract arguments are legally plausible enough to be tested through evidence. Customer harm is still alleged, not proven. The interest figures and rate comparisons come from court filings and the plaintiff's presentation of facts, which JPMorgan will challenge during litigation. The exact number of customers in the proposed class is not yet established in court. It could involve brokerage accounts, retirement accounts, or both, depending on how the class is ultimately defined. That question has not been decided. Class certification, the process that determines who is officially included, happens later. So why are these lawsuits surfacing now? The timing lines up with the sharp rise in interest rates over the past few years. When rates were near zero, sweep yields looked less unusual. Once short-term rates climbed above 5%, the gap between what banks earned and what customers received became more visible. Similar lawsuits have appeared against other banks, and regulators have already taken action in related areas. That environment has increased scrutiny on sweep programs. This case fits into a broader wave of consumer finance litigation where customers are questioning how banks profit from interest spreads. What this likely means is that courts are becoming a venue for defining how transparent sweep programs must be. Supporters of the lawsuit argue customers deserve rates that more closely track market conditions if contracts promise that flexibility. Critics argue banks disclose sweep structures and customers agree to the terms. The legal fight is about interpretation, what the written agreements actually required. For Americans, the practical impact is about money sitting quietly in accounts. If plaintiffs eventually succeed, customers could recover damages for years of low interest. Even before any final judgment, the pressure alone could push banks to adjust sweep yields or clarify disclosures. That would affect millions of brokerage and retirement account holders who often overlook idle cash balances. On the other side, large retroactive payouts would affect bank profits, which matters to shareholders and pension funds invested in bank stocks. What happens next follows a normal legal path. The case moves into discovery, where both sides exchange documents and testimony about how rates were set and explained. JPMorgan can still seek dismissal later through summary judgment if it believes the evidence favors its interpretation. Settlement is also possible. Many class actions resolve before trial to avoid years of uncertainty. If a class is certified and damages are calculated across a nationwide customer base, exposure could grow significantly, which is why similar cases are closely watched by the banking industry. It's important to separate this from what the ruling does not mean. JPMorgan did not lose the case. The bank is not being fined. Customers are not automatically entitled to refunds. Cash sweep accounts are not illegal, and they are not banned. The judge simply said the dispute deserves a full legal examination rather than being thrown out early. The story would become more serious if the class is formally certified and expands nationwide, or if regulators launch parallel enforcement actions. Internal documents showing intentional rate suppression would raise the stakes. If several major banks lost similar cases, the economics of sweep programs across the industry could change. The signals to watch are procedural but important: whether the judge certifies the class, whether settlement talks occur, whether regulators open new investigations, whether banks quietly raise sweep interest rates, and whether copycat lawsuits spread to competitors. Stepping back, this ruling is not a verdict. It is a doorway. A federal judge decided customers can continue arguing that JPMorgan's contracts required better interest treatment on swept cash. The outcome is uncertain, but the case highlights a simple issue many Americans rarely notice: how much their idle money earns while it sits in financial accounts. The court will now decide whether the bank's promises matched their practices, and that process could influence how sweep programs work across the industry.